Hi, it's Guy DiMartino. I'm a Northwest Indiana estate planning and probate lawyer. If you have any questions about an estate plan or probate matter and like to have an appointment, you can go to indianaestatemeeting.com and we can set up a phone call for you. We can set up a video conference for you. We can have you come in the office and we can sit down and discuss your concerns. Today I'd like to talk about the third area in which people start fighting in the probate process. The first area that I discussed was property, personal property, and where the stuff goes and who can get the heirlooms or stuff that the decedent left behind. The second area has to do with the personal representative or the executor. And the third area has to do with contesting a will. Now, typically, there are two ways to contest a will. Number one has to do with the formalities of the will. And the formalities mean that the person was of the right mind, the person knew what was going on, the proper witnesses were there, it was signed, it was dated, there's a self-affirming affidavit, whatever is required under the law to meet the requirements of a valid will. Typically don't see that too often. Typically what we see and what triggers a will contest is when a will has been changed shortly before the person passes away. That usually gets the hairs to stand up on the heirs or people who might have been written out of the will. And so at this point in time, when that happens, it triggers, concern in folks as to why did this happen and how did this happen and why did this happen so close to mom, dad, or grandma, grandpa's passing? And so the questions that need to be asked, going back to the formalities, is number one, and these are sort of intertwined, did mom, dad, grandma, grandpa have the mental capacity or the testamentary capacity at that point in time to enter the will, to change the will? Did they know what they were doing? Did they understand what they were doing? Was it of their free will that they were doing that? So that's the first area. Second area is intertwined, and that has to do with this concept of undue influence. And the concept of undue influence looks at this. Says, look, there was a person around who was sort of in a fiduciary or a close relationship, could be a kid, and this person had a whammy or put a whammy over their parent that they've taken care of. And because of that close relationship, that person used the relationship to unduly influence the changing of the will. And it might be, starting to get mom or dad or grandma and grandpa to start feeling sorry that none of the other kids or grandkids are helping take care, and look at Susie. Susie is doing the right thing by being there and taking me to the doctor and doing so and so. So some of the things that we look at to contest the will, one that's close to the time of death, is number one, who found the lawyer? Number two, how did the person get to the lawyer? Number three, did this person have control of the will after the will was written? Did they know the terms of the will? Number four, what was the physical and mental state of the person who changed the will? Were they just on the borderline of having mental capacity issues? Were they frail? Were they weak? Were they scared that if they did not go ahead and do this, that somebody would not take care of them, that Susie would no longer take care of them? So those are the things. Who paid for the lawyer? And if it wasn't a lawyer and they went online to change the will, who logged into the account, who paid for the will, who filled out the information online, all those things. You see, if grandma or grandpa or mom and dad want to go in and change their will, they need to really do that on their own volition. They need to find the lawyer or go back to their other lawyer. They can have somebody drive them, but that person cannot go in the room with the lawyer. The person needs to sit with the lawyer alone, explain to the lawyer that these are their wishes and the reason why. The lawyer is going to ask them questions to determine if they understand the nature of their property and why they're doing these things, trying to tease out if there's something going on. You see, if all that happens and Susie just took grandma or mom to the lawyer, then there's not going to be a claim for undue influence. But if Susie was instrumental in getting this will to change, then you bet. Close proximity to death, the person that takes more under the will now was actually around the decedent a lot more than everybody else in the family at that point in time. Those are the red flags, and I get so many phone calls regarding that issue. If you have any questions about an Indiana estate matter, you can always give me a call or go online to indianaestatemeeting.com. I am Guy DiMartino. Have yourself a great day.